all take your seat? Shrotriyasya cha medhavi vidyavancha bhavantihi. A good listener becomes intelligent and knowledgeable in life, and true wisdom begins with the willingness to learn from those experienced. A very good evening and warm welcome to all. Honorable Shri Justice UJJAL BHUYAN, Honorable Shri Justice Nitin Sambre, Honorable Vice Chancellor of Rashtra Sant Tukadoji Maharaj Nagpur University, Dr. Prashant Bokare, Principal of Dr. Babasaheb Ambedkar College of Law, Dr. Ravi Shankar Moore, all the legal luminaries, participants, and the present audience. On behalf of Rashtra Sant Tukadoji Maharaj Nagpur University's Babasaheb Ambedkar College of Law, Nagpur, I, Supriya Ranade, along with my co-compere Harshita Pandey, extend our heartiest greetings in the guest lecture of the 22nd JUSTA CAUSA National Law Festival of Brilliance and Youthful Aspirations.
Let us commence the event by lamp lighting ceremony, hoping that like the kindle of flame in the lamp, we shall ignite the spirit of learning among ourselves and enlighten our mind. I request Honorable Shri Justice UJJAL BHUYAN, Honorable Shri Justice Nitin Sambre, Honorable Vice Chancellor of Rashtra Sant Tukadoji Maharaj Nagpur University, Dr. Prashant Bokare, and Dr. Ravi Shankar Moore, sir, to light up the lamp, marking the auspicious start of the event. Let us hope that as we bathe in the pious light of the lamp, it shall guide us to the world of knowledge.
By the way, airplane mode is on, so you won't hear new notifications.
We beg your pardon. I request all to kindly rise for the university song. I request Dr. Ravi sir to kindly usher the dignitaries to the dais. To formally extend our greeting to the dignitaries on the dais, legal luminaries present, and all the audience, I request Dr. Ravi sir to kindly deliver the welcome address.
Honorable dignitaries on the dais, distinguished guests, faculty, students, ladies and gentlemen, a very warm good afternoon to one and all. We have with us Honorable Lordship Sri UJJAL Bhuyan sir, sitting Judge Supreme Court of India. We have with us Mrs. Bhuyan. We have with us Senior Administrative Judge Sri Nitin Sambre sir and our own Vice Chancellor Dr. Prashant Bokare sir. I welcome you all sir in this wonderful evening in our institution which is celebrating our 100th year of establishment. Welcome sir. It is with immense pleasure and proud sense of honor that I welcome you all, dignitaries sitting in the audience, my colleagues, friends, judges, advocates from the bar, participants from various colleges in the country, and my own dear students of the institution. Dear students, Justa CAUSA guest lecture series is one of the hallmark of our Justa CAUSA event. Your Lordship, Justa CAUSA event is a feast for the law students, and this occasion of Justa CAUSA is waited for a long throughout the year, not only by the students of this college but from the various colleges who have won the trophies in various competitions, and they eagerly wait for the happening of Justa CAUSA each year in our college. This year, this is 22nd episode of Justa CAUSA. Even during the period of COVID, when entire nation was locked down, our students, they decided to continue with Justa CAUSA in virtual mode. We had competitions, we had interactions, and that year Justa CAUSA was spread over. Throughout year we organized different competitions, and Justa CAUSA was not only 3-day event but a complete year around event. So Justa CAUSA has got its own brand. This year we have special occasion of centenary celebration of the college. This college, since its establishment in the year 1925, till today have seen various luminaries who were on one occasion or other were the students sitting in the very same hall of this auditorium as a student of the institution, be it former Chief Justice of India, Sri Sharad Bobde, well-known name in the legal field, a jurist, Advocate Sri Harish Salve, or many former judges of Supreme Court and High Courts in India. Dear students, this year we are having a special occasion to welcome Honorable Lordship Sri Justice Bhuyan sir. His judgments and his work as a jurist and judge have ad hoc judgment that in any bar association at least 3 positions should be reserved for women, lady lawyers. So this can happen. Having your lecture on the constitutional topic will be a real feast, intellectual feast for the student to listen. Our teachers are eagerly waiting to listen you. I welcome you once again. Thank you. Have a nice day.
Thank you, sir. It is an honor to have with us distinguished guests on the dais. It gives us immense pleasure to welcome all the dignitaries. I request the chairperson for the event, Honorable Vice Chancellor of Rashtra Sant Tukadoji Maharaj Nagpur University, Dr. Prashant Bokare sir, to felicitate and welcome our chief guest and guest lecturer, Honorable Shri Justice UJJAL BHUYAN sir, Judge, Supreme Court of India, with shawl, shreefer, memento, and a gift as a token of her love and affection. Thank you. We also appreciate the presence of Mrs. Bhuyan in this event of ours. I request Dr. Praveena Khobragade Madam to accord a floral welcome to Mrs. Bhuyan Madam. Moving forward, I request our principal, Dr. Ravi Shankar More sir, to felicitate and welcome our guest of honor, Honorable Shri Justice Nitin Sambre sir, Judge, Bombay High Court, Bench at Nagpur, by presenting him a bouquet and a memento. It was in the presence of Honorable Shri Justice Nitin Sambre that 22nd Justa CAUSA was inaugurated. I now request Madam Sakshi Kanchanwal to welcome Honorable Vice Chancellor of Rashtra Sant Tukadoji Maharaj Nagpur University, Dr. Prashant Bokare sir. We once again express our gratitude and delight with having us honorable dignitaries on the dais. Today, we are graced with the presence of Honorable Vice Chancellor of Rashtra Sant Tukadoji Maharaj Nagpur University, Dr. Prashant Bokare sir. Sir is a seasoned academic with over 34 years of experience in civil engineering, specializing in traffic engineering and data analytics. He holds a PhD from IIT Guwahati and has enhanced his expertise with certification in data science from IIM Raipur. Sir has served as principal and dean of renowned institutions and has made significant contributions to traffic simulation, rural technology, and traditional industries through his work. Sir has published 32 research papers, guided 8 research projects, and played a pivotal role in institutional accreditations. His work in traditional industries led to the development of smart, sustainable, and manageable rural technology concept, promoting innovative solutions for rural crafts. We are grateful for your presence, sir. I request you, sir, to kindly address the House.
Honorable Justice Bhuyan, the sitting Supreme Court Judge, Honorable Justice Nitin Sambre, Senior Administrative Judge of Bombay High Court, Nagpur Bench, Dr. Moore, whose innovative ideas have brought real life to JUSTA CAUSA, all the faculty members, our Management Council member Dr. Samay Bansod, faculty members of Law College, all the participants of JUSTA CAUSA, and my dear students. It's once again a matter of pride to address you all on this 22nd JUSTA CAUSA, because it is happening in 100th year. Yesterday evening I addressed you, today morning I addressed you at Vidhan Bhavan, and once again I am addressing you today evening. This is like one teacher taking 3-4 classes a day, and that I am witnessing from your faces कि और कितना बोर करेगा. But you don't worry, I won't be boring you, and I know all of you are much eager to listen to Justice Bhuyan. The importance of the great visionaries and the legal luminaries coming over in the college is that by their sheer presence, the atmosphere is enlightened. When the bigwigs come to you, by their body language, by their speeches, you can gather a lot of things for your future life. And that's why I congratulate Dr. Moore and his team that they are trying their level best to bring the big names in the circle of law in this college. I am also witness to one another event which I shared with Dr. Moore, that he has invited Advocate Harish Salve to deliver a similar guest lecture in this Dr. BABASAHEB AMBEDKAR College of Law. So all these things are the big opportunities for all the students, because if you look at Justice Bhuyan and if you listen to his speech carefully, not all but probably few of you will always aspire to become the judge of the Supreme Court. If you listen to Justice Nitin Sambre, not all but few of you will be inspired to become the judge of the High Court. So this is the big thing, sir, for the students, because you know, if you don't look at the Everest, you don't understand the height of the peaks. So that's why we should always look at the people who are greater than us, who are the bigwigs in our business, and would like to go to follow their footprints. So this is the importance of all these people coming over to the college, and I hope this is an opportunity for you, and you will surely not lose this opportunity. We listen to him very carefully, and the most important takeaway, that you get inspired from his speech. So I once again congratulate the team JUSTA CAUSA, and I hope that in 101st year, and after that also, they will maintain this track record. And I congratulate all of you that you have become the part of Justa Causa in the 100th year, in the century year of the Dr. Babasaheb Ambedkar College of Law. So I once again thank the organizers for calling me over here, and I congratulate the team once again. Thank you.
Thank you, sir. We would be more than delighted if our favorite teacher were to take even 4 classes a day. Thank you once again.
We consider it a privilege once again, sir, to have the presence of Honorable Shri Justice Nitin Sambre, Judge, Bombay High Court, Bench at Nagpur. Born on 19 December 1967, His Lordship graduated in law in the year 1992 from University of College of Law, Nagpur, and enrolled as an advocate in the same year. His Lordship was the Secretary of the High Court Bar Association, Nagpur, for 2004 to 2007, and represented Governor of Maharashtra in the High Court bench at Nagpur. His Lordship was appointed as government pleader and public prosecutor in 2007. Sir has been standing counsel for public undertakings such as Bharat Petroleum Corporation Limited, and has represented statutory bodies such as various municipal corporations. His Lordship was elevated as a judge of Bombay High Court on 6 January 2014. We are extremely delighted by your noble presence and would like to extend our humble invite to you to kindly address this august gathering.
Honorable Justice UJJAL BHUYAN, Judge, Supreme Court of India, Mrs. Sangamitra Bhuyan, Dr. Bokare, our Vice Chancellor, Dr. Moore, Principal of the College, former judges of the Bombay High Court, Justice Gilani, Justice Rohi, faculties, Mr. Tiwari from National Law School, Nagpur, Mr. Bansod, Academic Council member, dear students, I could see some lawyers also present today. Just in the beginning, I would like to begin with 2 suggestions. There is some difference in this hall. I yesterday narrated that when I entered this hall, it reminds me of my student days. I occupied these chairs as a student, and my teacher used to give lessons from here. But today there is an addition, sir. We could see some photos displayed on the wall. These are all the luminaries who studied in this college. And not only this college, but these luminaries also feel proud of they were student of this college like me. A suggestion is that let there be a photo gallery of all these luminaries. The second suggestion is, Madam, yesterday also I was introduced, and only one thing you lost while mentioning, that I was president of the students of this college, sir. Sorry. What this college has taught me, what courage this college has given, while I practiced in the profession, 1 or 2 my experiences today I would like to share with you, which will definitely help you in your future life while shaping up as a lawyer, while shaping up as an academician, or wherever you want to work as a lawyer or else with this background of law degree. Yesterday I narrated, we used to have teachers and who never insisted upon that you must have attendance, and the students were eager to attend those classes. So The students responded by great applause, saying that they don't want insistence that the student must mark their attendance. But let me tell you that it was the dedication of the students at the relevant time, perhaps, which when the students were never after gaining attendance, what they wanted was to attend the classes and gain knowledge. The teachers never demanded respect, they commanded respect from the student. And after I started practicing as a lawyer from Justice Bobde's chamber, a brief came to be allotted to me for argument. And it was really a shocking matter for me because I was required to argue a matter against a teacher who taught me at that time in this college. A student from this college who was having a strong legal background, whose father was a senior lawyer, whose every member from the family was a lawyer, was given some dressing for unruly behavior in the class by the teacher at that time. The student took it offending, and it was stretched to the extent of making allegation against the teacher, a very respected teacher for everybody, that the teacher tries to victimize this student. And this was a case which I was required to argue for the student against my teacher. Of course, the litigation was not successful. The student never won the matter. But two things I have learned from this experience. The one, that in discharge of your professional duty as a lawyer, you should never compromise with what is the subject matter, the subject matter should not rather take you to a feeling that you are unable to perform or discharge your duties as a lawyer. Out of this only, as a judge, I gained certain experiences when I was sitting in Bombay. I still remember when I was young, I was studying in school. In school, suppose if we don't do homework or if we are not properly prepared in spite of there being warning, there used to be some punishment, maybe at times in physical form. And this punishment which we used to get, if reached to our home, there used to be a second round of punishment from our parents. Those used to be days. Perhaps now the things have undergone lot many changes. But while deciding the cases in Bombay, I came across certain litigation. Let me share this with you because all of you are also going to be the parents in future. I've seen the parents initiating litigation against the teacher just for scolding, alleging that such scolding has resulted into the child suffering depression. And let me tell you, the best of the brains who used to charge in lakhs were engaged by these parents to pursue the case against the teacher, and the poor teacher used to occupy the corner of the court with just folded hand. His salary was just 60,000, 70,000, what he could pay from his pocket to defend his case. As a judge, I have witnessed such incidents also. See, these two experiences, why I am narrating with you students. I told you that you are going to be the parents tomorrow. Don't stretch or don't blow the issues out of proportion against your teachers. They are not your enemies. They don't have any enmity with any of the students. They are not going to victimize you. It's not their job. They are not going to do this. And if you have such feeling, have a dialogue, get it resolved. But don't stretch the things to such an extent that you are required to take your teachers to the court of law. With all these, I again thank you for inviting me for this Justa Causa. This is perhaps after Justice Dr. Bokhare, Dr. Moore, perhaps I'll be the third person to deliver repeated speeches here. Thank you so much.
Thank you, sir, once again for your motivational words. Justice, though it may be blind, is guided by wisdom, integrity, and an unwavering commitment to truth. Today, we have the honor of hearing from a beacon of these ideals, whose words will inspire and enlighten us. We consider it our honor to be in the company of Honorable Sri Justice UJJAL BHUYAN, Judge, Supreme Court of India. His Lordship, born on 2nd August 1964 in Guwahati, completed his schooling at Don Bosco High School, Guwahati, and graduated in arts from Karorimal College, Delhi. Before earning his LLB from Government Law College, Guwahati, and LLM from Guwahati University, enrolled with the Bar Council on 20th March 1991. His Lordship practiced extensively across various legal forums, including the Guwahati High Court and its benches, and served in prominent roles such as Standing Counsel for the Income Tax Department for 16 years, Additional Government Advocate for Meghalaya, and Special Counsel for Arunachal Pradesh Forest Department. Designated as Senior Advocate in 2010, His Lordship was appointed Additional Advocate General of Assam in 2011. He served as a judge at Guwahati, Bombay and Telangana High Courts, eventually becoming Chief Justice of Telangana High Court in 2022. Elevated to the Supreme Court of India on 14 July 2023. His Lordship has also contributed significantly to legal education, holding key position at NLSIU, Bangalore, and Maharashtra National Law University, Aurangabad, while championing access to justice through state legal services authorities. We are truly honored for having this precious opportunity to be in your noble company. And so I take this very opportunity as a privilege to invite you to address the House and fulfill our eager anticipation to hear your valuable thoughts.
My former colleague in the Bombay High Court, Justice Nitin Sambre, who is presently the Senior Administrative Judge of Nagpur Bench of Bombay High Court. Former judges of Bombay High Court, Justice Rohi and Justice Gilani. Vice Chancellor, Dr. Prashant Bokhare. Principal, Dr. Ravi Shankar Moore. Faculty members of Dr. Babasaheb Ambedkar College of Law. Member of Academic Council of the University. Professor Tiwari from Maharashtra National Law University, Nagpur. Learned advocates, distinguished guests, my dear students, ladies and gentlemen, a very good evening to all of you. I really feel very honored and privileged to stand before you in this esteemed institution. The photographs adorning this hall, and which my friend was saying we should have a photo gallery, and indeed I endorsed that. It's a humbling experience to stand before such tall figures. Today, as I address this august gathering, I am reminded of the vision of the great luminary after whom this institution is named. But before I formally start my speech, let me thank the college for inviting me here along with my wife to this institution to be part of this celebration of JUSTA CAUSA. Justice Sambre, as I said, was my colleague here. In fact, while at the principal seat at Bombay, our chambers were adjacent to each other. So people used to fondly say, this is the chamber of the tiger from Nagpur, and this is the chamber of the rhino from Assam. So, Brother Sambre represents everything that is good about Nagpur and Nagpurians. The essence of Nagpur and the Nagpurians, the large-heartedness, the warmth in embracing others, making you feel at home, feeding you, and making you happy. That's what Nagpur stands for, and that's what Nagpurians have always been doing. Dr. Ambedkar was a giant in the true sense of the term. I have been studying his works. In fact, his collected works, speeches have been published by the government of Maharashtra when Mr. Sharad Pawar was the education minister in 1970s. His collected works are there. But only after coming to the Supreme Court, I have now critically going deep into what Ambedkar stood for and what he wanted India to become. The more you research into his work, the more and more you will be convinced about the philosophy of Dr. Babasaheb Ambedkar. A great man, far ahead of his time. In fact, far, far ahead of his time. His emphasis on education as the ultimate tool for societal transformation resonates profoundly in the ethos of this college. Dr. Babasaheb Ambedkar College of Law has long been a hub of academic rigor and intellectual exploration. It is not just a physical infrastructure. Of course, you should be proud of the infrastructure that you have. But the institution's commitment to fostering a comprehensive understanding of law, not just as a profession, but as an instrument of justice and equity, is truly commendable. The previous speakers have said that this college stands as a proud alma mater to some of India's most distinguished personalities. I am told Justice Vivian Bose was a principal of this college in the earlier years. Justice Hidayatullah, Justice Tirpurkar, Justice Ruma Paul, and Justice Sharad Arvind Bobde are some of the notable alumni of this college. There are many others, as you can see, who have served the judiciary and the nation with great distinction. Lawyers like Harish Salvi, V.R. Manohar, Shashank Manohar, they have all studied, they are all past pupils of this college. The former Prime Minister of India, P.V. Narasimha Rao, Cabinet Minister Nitin Gadkari, the present Chief Minister of Maharashtra, Devendra Fadnavis, they are all pass-outs from this great institution. Together, these alumni exemplify the legacy of this college in nurturing young minds who have gone on to excel across diverse fields. This illustrious legacy is complemented by a dedicated faculty. It was a wonderful experience interacting with the faculty today, who have mentored the students not only to become successful legal professionals, but also conscientious citizens, well equipped to face the challenges of an evolving world. The mentorship offered here will certainly encourage you to engage deeply with issues of justice, equality, and human rights that form the bedrock of any thriving democracy. Friends, we have celebrated 75 years of our Constitution. Our founding fathers, led by Bharat Ratna Dr. Babasaheb Ambedkar, have gifted us a most vibrant document, the Constitution of India. The courts, judges, lawyers, teachers alike are guided by the vision of our Constitution. There are several salient features of the Constitution. Wherever I go, I ask my audience, mostly students, please tell me which provision of the Constitution is the most important. Some would say preamble to the Constitution. Some would say Article 19. Some would say Article 21. I agree with them. Each one of these provisions are important. They are most basic. But according to me, if you ask me, according to me, the very essence or the soul of our Constitution is equality. Equality between men and men, equality between men and women. This is the cornerstone of our Constitution, which is traceable to Article 14. Our Constitution, so framed, has transposed a deeply feudal and fractured society practicing graded inequality into a modern, forward-looking society. And this march into a modern, forward-looking society should never be halted. The march can only move forward, it can't be recoiled. There can be no discrimination on the basis of one's birth and gender. And gender includes now the orientation. To strive for, it may sound very, very simple today, very easy, equality, everyone. But it was not so if you look at this society when this Constitution was adopted 75 years ago. To strive for equality in a deeply unequal society, affirmative action has now become an inseparable part of our constitutional scheme. In fact, it has become a facet of equality itself. As we shall deliberate upon as we move ahead, we will see that it is now firmly established that Articles 15(4) and Articles 16(4) of our Constitution, which speaks about providing some affirmative action for socially and economically backward segments of this society, they are manifestation of substantive equality and not an exception to equality. We have decisively moved from formal equality to substantive equality. Granville Austin, he has written several books on the Indian Constitution. He has described the Constitution of India as a social document, the primary objective of which is to build a democratic and equitable society. According to me, I would go one step ahead and I would say that our Constitution is a transformative document. The transformative intent in the Indian Constitution is discernible in its shift from an unequal society to one that upholds justice, equality, and dignity for all. The Constitution addresses issues of caste discrimination, untouchability. The college song also speaks about, I could understand that, about removal of untouchability and gender inequality, and gives importance to concepts of equality, liberty, and fraternity, which reinforces the ideals of social democracy. The transformative potential of the Indian Constitution is more prominent in the directive principles of state policy, which mandates that the state shall strive to promote a just social order, ensure equitable distribution of resources, and provide for the right to work. Dr. Ambedkar considered the Indian Constitution as a weapon for bloodless revolution. We have talked about equality, we have talked about formal equality, we have talked about substantive equality, but what is equality? As a concept, as a theoretical concept, what is equality? The significance of the equality clause in our Constitution can be gauged. Before we proceed to that, let me give you one simple example. It can be gauged from only one aspect, and that is conferment of the voting rights. For us in India, the concept of universal adult franchise, or that of one citizen, one vote, is taken for granted. It is passing, it is taken for granted. But to understand the significance of it, just take the case of the United States. Initially, the right to vote was granted only to white men. Women, African Americans, and Native Americans did not have the right to vote. It was much later that African American men got the right to vote. But that was also made subject to certain conditions, like payment of poll tax, you have to pay a tax, and also having certain educational benchmarks. In 1920, white women won the right to vote. African American, both men and women, women and Native American, both men and women, had to fight for many more years to secure the right to vote. But Article 326 of our Constitution has promised us political equality. The priest in the temple, the sweeper who cleans our drains, both have equal voting rights. Their votes are equal. Every citizen of India who is above 18 years of age, earlier it was 21 years of age, has the right to vote. Now, coming back to the concept of, the theoretical concept of equality, Dr. Ambedkar was once asked that, Babasaheb, since you have repudiated the caste system, he has rejected the caste system as being totally unproductive economically, socially divisive. What kind of a society would you wish for? He was asked. And his reply was that I would aspire for a society, an ideal society, which is a society based on liberty, based on equality, and based on fraternity. Kindly mark the words: liberty, equality, and fraternity. This very thought process of Dr. Ambedkar finds mention, full manifestation, in the preamble to the Constitution of India, which speaks about liberty, equality, and fraternity of the people of India. Dr. Ambedkar explained the three concepts as another name for democracy. According to him, democracy is not merely a form of government. It is primarily a mode of associated living, of conjoint communicated experience. This is how he explains. It is essentially an attitude of respect and reverence towards our fellow human beings. We treat each one of us as equal, not someone whom we can subjugate. Explaining the concept of equality, Dr. Ambedkar highlighted that equality was a fiction. All men are not equal. They are not born equal. A man's ability and competence is dependent upon his physical heredity and social inheritance or endowment in the form of parental care, education, etc. He then posed the question, do we treat unequal men as unequal merely because they are unequal? And then proposed himself that it would be desirable to give incentives for full development of those who are less equal. He gave an analogy of a race. Referring to that race, he says, it is obvious that individuals in whose favor there is birth, there is education, there is family background, they would be selected in the race. They would be way ahead in that race. But such a selection would not be a selection of the able. It would be a selection of the privileged. Therefore, he suggested that it was necessary that rules of the race should be changed to bring about an equilibrium so as to make the competitor equal in the race. That brings us to 15.4 and 16.4, which are manifestation of substantive equality and not an exception to equality. We all know, we are students of law, 15.1 and 16.1 are principles of formal equality. When we talk about these two provisions, it is natural that the question of reservation in educational institutions and in public employment as a form of affirmative action comes to the fore. This is a touchy subject, we have to deal with it. Earlier view of the Supreme Court was that reservation was an exception to the principle of merit, but it was a social necessity. This was the view of the Supreme Court earlier. In the process, a binary was sought to be created between merit and reservation, where reservation becomes antithetical to establishing meritocracy. To be fair to the earlier generation of judges, the genesis of such an argument could be traced to the debates in the Constituent Assembly itself. The initial view was that Articles 15.4 and 16.4 were exceptions to the general principle of equality manifest in Articles 14, 15.1 and 16.1. Therefore, merit was equated with formal equality of opportunity, which had to be balanced against the concerns of social justice, primarily through reservation. Thus, affirmative action was seen as a deviation from the principle of formal equality. Friends, it is not that such conservative view, if I may say so, went unchallenged. Justice Subbarao, in his dissenting opinion in the case of T. Devadasan, AR 1964 SC 179, expressed the view that Article 16.4 was not an exception, rather a facet of Article 16.1, which sought to redress the historical disadvantages suffered by certain communities. So he then elaborated on this. This minority view of Justice Subbarao in T. Devadasan was finally accepted by the Supreme Court in the famous case of N.M. Thomas. N.M. Thomas is State of Kerala versus N.M. Thomas, 1976, 2 SCC 310. This decision transformed the equality jurisprudence in India from that of formal equality to substantive equality, and also changing our understanding of reservation. Equality of opportunity for unequals can only mean aggravation of inequality. Therefore, differential treatment in standards of selection is within the concept of equality. From N.M. Thomas onwards, Supreme Court has accepted that special provisions, affirmative action, including reservation, made for the benefit of any class are not an exception to the general principle of equality. Such provisions are a method to ameliorate the structural inequalities that exist in our society, without which true or factual equality will remain illusory. Now, this has been accepted, Indira Sawney, on all these cases, that 15.4 and 16.4 are nothing but a restatement of the guarantee of the right to equality. Finally, in 2022, in the case of Neil Aurelio Nunes, the bench headed by then Chief Justice, Justice Chandrachud, finally concluded that the crux of the above discussion, this is in the words of the Chief Justice of India, is that the binary of merit and reservation has now become superfluous. Once this court has recognized the principle of substantive equality as the mandate of Article 14 and as a facet of Articles 15.1 and 16.1, an open competitive exam may ensure formal equality, where everyone has an equal opportunity to participate. However, widespread inequalities in the availability of and access to educational facilities will result in the deprivation of certain classes of people who would be unable to effectively compete in such a system. A combination of family habitus, community linkages, and inherited skills work to the advantage of individuals belonging to certain classes, which is then classified as merit, reproducing and reaffirming social hierarchies. Special provisions like reservation enable such disadvantaged classes to overcome the barriers they face in effectively competing with forward classes and thus ensuring substantive equality. Supreme Court says that we cannot have arid equality which does not take into account the social and economic disabilities and inequalities from which large segment of people suffer in the country. Equality in law must produce real equality on the ground. De jure equality must ultimately find its raison d'etre in de facto equality. So therefore, friends, post N.M. Thomas, we can firmly say that there is no constitutional basis to subscribe to the binary of merit and reservation. Reservation is a facet of merit, which is a facet of equality. That conclusively concludes any debate on this point. Now, friends, in 2023, we have celebrated 50 years of the landmark case of Keshavananda Bharati. All of you, there is a lot of literature on this. I am not going to say what is it. Repeat all that. This is about Article 368, the power to amend the Constitution. In 1971, Parliament amended Article 368 to supersede the majority decision in Goloknath. Goloknath, as you all know, it's a bench of 11 judges, a majority of 6:5. It was held that though there is no express exception from the ambit of Article 368, but fundamental rights by their very nature could not be subject to the process of amendment under 368. Now, this was a clear departure from the previous decisions till then, till that point of time, which said that no part of the Constitution is unamendable. Every part is subject to the rigor of amendment. Parliament may, by passing a Constitution Amendment Act in compliance with the requirements of Article 368, amend any provision of the Constitution, including the fundamental rights and 368 itself. But all these decisions were overruled in Goloknath. Now, the amendment which was brought in 1971, it said two things to overcome Goloknath. It said, number one, that an amendment to the Constitution would not be a law within the meaning of Article 13. Secondly, validity of a Constitution Amendment Act would not be open to question on the ground that it takes away or abridges a fundamental right. These are the two things which were brought in by the Constitution Amendment in 1971. This came to be challenged in Keshavananda Bharati. It came from the state of Kerala. A bench of 13 judges of the Supreme Court, till now it is the largest ever bench in the Supreme Court, again by a majority of, wafer-thin majority of 7:6, declared that by way of amendment under Article 368 of the Constitution, the identity of the Constitution cannot be destroyed. The basic structure or the basic features of the Constitution cannot be altered through the process of amendment as provided in Article 368. The majority held that 368 did not admit, that though 368 did not admit of any implied limitation on the amending power, the very meaning of the word amend would mean that while any piecemeal change may be made, the old Constitution cannot be totally destroyed or so radically changed so as to lose its identity. Hence, the basic structure or basic features of the existing Constitution cannot be amended through the process of amendment as provided in Article 368. Therefore, the amendments were held to be valid and the decision in Goloknath was overruled. Well, though the executive and the political establishment at that point of time should have been happy with this verdict because the amendment were upheld, they were in fact not happy. They were unhappy with the basic structure theory developed by the Supreme Court. Now, I am pausing here for a moment. This basic structure theory did not come overnight. Before partition, I got it from the book written by Justice H.R. Khanna, Neither Thorns, forgot it, now roses. Correct. So, he was, before becoming a judge, district judge in Firozpur, he was practicing in the district courts at Amritsar. So, the district judge at that point, these are pre-partition days, district judge at Amritsar was Cornelis, a Christian, a European Christian. Whether it's European or I don't know, but he was a Christian. Post-partition, he went over to Pakistan and went on to become Chief Justice of Pakistan. In 1966, in a case in Pakistan, he had propounded the doctrine of basic structure, which he said the Constitution of Pakistan has got certain basic elementary features which cannot be done away with by way of amendment. Justice Budholkar in Goloknath had also stated about this concept of basic features, which found it, so it's not something that H.R. Khanna suddenly developed this theory and circulated it in a one-page note which was signed by 9 judges and became the ratio of Keshavananda Bharati. It's not that. Overnight, it did not come overnight. It was a long thought process. This judgment was criticized as anti-democratic. And the criticism continues till date. I'm a sitting judge. I have my own limitations. I will not say. There are many people who criticize these judgments, this judgment. But according to me, such criticism has no substance at all, legal or constitutional. I think our principal Saab also said in the morning that can we not go back, can we not relook into Keshavananda Bharati? Well, there are certain things in the life of law and the community which are like the rock of Gibraltar. They are there to protect our community, our country, and our system which we follow. This judgment in Keshavananda Bharati has been followed in not less than more than 10 Constitution Bench judgments. Constitution Bench means 5 judges and more, including in Indira Nehru Gandhi, Minerva Mills, Vaman Rao, Coelho, Keynote Holohan, S.R. Bommai, L. Chandrakumar, M. Nagraj, the NJ judgment. And the list goes on. In fact, if you look at closely, I won't go into the facts, in Indira Nehru Gandhi case, it was a unanimous decision by 5 judges, applying the basic structure doctrine. Out of these 5 judges, 4 judges were in the minority in Keshavananda Bharati. They did not subscribe to the doctrine of this basic structure. Yet, once this became the law of the land, they applied it. And unanimously held in Indira Nehru Gandhi that you cannot do this. By way of amendment of the Constitution, you cannot do away the power of judicial review, the challenge to election of President, Vice President, Speaker, Prime Minister, etc. So this is an example of, the judicial precedent that we follow, and judicial discipline. In Keynote Holohan, the Supreme Court declared democracy to be a basic feature of the Constitution. Free and fair elections, basic feature. In a plethora of judgments, including in L. Chandrakumar, Supreme Court has asserted that independence of the judiciary is a basic feature of the Constitution. It is non-negotiable. It is the sine qua non for democracy. In S.R. Bommai, Supreme Court declared secularism to be a basic feature of our Constitution. There are many views expressed that secularism was not there in the original text of the Constitution. It was only brought in by way of the 42nd Amendment. And this was one of the challenges before the Supreme Court in a recent judgment. Chief Justice of India, Justice Khanna, has completely rejected this argument. It is a way of life. Secularism is an Indian way of life. We respect each other. We respect each other's faith. This is the basic feature of our Constitution. In fact, very recently, on the 25th of December, I was addressing the journalists in Guwahati, the award-giving function. And I said, no constitutional functionary who has taken oath to uphold the Constitution can speak against the Constitution. They cannot speak against the values of the Constitution. They cannot speak against the essential features of the Constitution. So friends, after this reaffirmation and extension of the applicability of the doctrine of basic structure, it is now clear that so long as Keshavananda Bharati holds the field, it's a bench of 13 judges. To overturn this, you will have to constitute a bench of 15 judges. No amendment to the Constitution would be immune from challenge on the ground that it affects one or the other of the basic features of the Constitution. Friends, only one more judgment I'll refer to, otherwise my speech will remain incomplete. And that is the judgment in Maneka Gandhi. But before I come to Maneka Gandhi, a word about judicial review. I had spoken about independence of the judiciary. Appointment of judges through the collegium system is one facet of independence of the judiciary. Independence of the judiciary is not hinged upon the appointment process. There are various processes which are inbuilt to protect the independence of the judiciary. Ours is a parliamentary democracy. But we are also a constitutional democracy. We have a constitution. As a constitutional democracy committed to the rule of law, we have several checks and balances. We have separation of powers on the one hand, executive, legislature, judiciary, and on the other hand, the power of judicial review exercised by the judiciary, which acts as a checks and balance on the abuse of power. Now this is a fundamental principle. Judicial review is a fundamental principle of constitutional law. Students of constitutional law will know that this principle is traceable to the famous American case of Marbury versus Madison, in which Chief Justice John Marshall had famously declared that every action of the state, be it a legislative act or an executive one, if repugnant to the Constitution, is void. And the courts, constitutional courts exercising the power of judicial review, has the mandate to strike down such act. We all know that in 2014 the Constitution was amended by the Constitution 99th Amendment Act, which was followed by the National Judicial Appointments Act 2014, providing for a National Judicial Appointments Committee, replacing the collegium system. There's another debate, I am not going to that, which will take it will require a full session. I am not going to that. This was challenged in the Supreme Court by the Supreme Court Advocates on Records Association, and in that case, Supreme Court struck down both the Constitution Amendment Act as well as the Judicial Appointments Act, though the Constitution Amendment was ratified by both houses of parliament, 2/3 members of both houses of parliament, and almost all the states of the country, legislatures of all states of the country, and declared this as void principally on two grounds. It's a direct breach, attack on the separation of powers, and secondly, it is an assault on the independence of the judiciary. I will not go deep into the judgment. Now, the then law minister, late Arun Jaitley, I was watching a television debate, Justice Lodha was also there in that debate. He was so upset with this development, with this judgment, that he criticized the judgment as a tyranny of unelected judges. According to him, judges are not elected, they are not answerable to the people. Members of parliament are answerable to the people, they are elected people. Not only they draw their authority directly from the people, but are also answerable to the people. Lawmaking is within the domain of the parliament, clear separation of powers. Therefore, the Supreme Court ought not to have set at naught the will of the people manifest in the form of the Constitution Amendment and the law. There was quite a lot of reaction to that. According to me, this criticism that unelected judges of constitutional courts should not interfere in lawmaking by the elected representatives of the people has no constitutional basis. This is because the Constitution has mandated the Supreme Court the power to examine whether law made by the Parliament conforms to the constitutional requirement or not, and if it is not, to strike down the law. And this is what exactly the Supreme Court did in the NJAC judgment. Now, coming to the Maneka Gandhi case, this is my last case which I would refer. Now, before we deal with Maneka Gandhi, we have to go back in time. In 1950, immediately soon after India became independent, and we had our Constitution and our Supreme Court. A.K. Gopalan, a formidable communist leader from Kerala, was arrested under the Preventive Detention Act 1950 by the then government of Madras. This came to be challenged by Gopalan. Various grounds were given by Gopalan. We need not go into. He said this arrest is arbitrary, violative of 14. This arrest prevents me from speaking out, prevents me from moving out, therefore it is violative of 19. This arrest confines me to the prison without following the due process, therefore it is violative of 21. So he said 14, 19, 21 are all interrelated, all are violated, therefore strike down. My arrest is illegal, preventive detention. But the majority in A.K. Gopalan held two things they held. Basically, many things were there, two things basically they held. One is that 14, 19, 21 are not interrelated. They have to be, if an attack is made on the basis of 14, it has to be substantiated by that 14. If it is, you can't fall back upon 19 and then 21. These are all separate. Secondly, the majority held that what Article 21, all of you know, it's a one-line article. No person shall be deprived of his life or personal liberty except according to procedure established by law. This is a one-line article. So the majority held that what Article 21 requires is that there must be a law. Law must be validly enacted by the lawmaking authority. Secondly, the law must provide a procedure whereby you can be deprived of your liberty. As if these two conditions are fulfilled, your detention is valid. This was the majority view. It was argued on behalf of Gopalan, in addition to this 14, 19, 21 argument, that the principles of natural justice, that the law must be fair, the procedure must be fair, it must be reasonable, was rejected by the majority. The majority said that principles of natural justice are very vague. We cannot read into our constitution vague principles of natural justice. Maybe these were early days of our republic, 1950. There was one dissenting voice, and Justice Fazal Ali. He said, no, natural justice is inbuilt in our system. The law must be fair, the law must be reasonable. It must meet the test of reasonableness to satisfy the test of Article 21. Maybe Justice Fazal Ali's views were too ahead of his times. It was in that bank nationalization case in 1970, R.C. Cooper's case, that Supreme Court rejected this 14, 19, 21 as islands argument and said these are intrinsically related. Violation of 19 can lead to violation of 21, violation of 21 in turn can lead to violation of 14. There cannot be any separate, they are not separate organs of the body, they are all intrinsically connected. And later in 78, in Menaka Gandhi, the ghost of A.K. Gopalan was finally buried. Menaka Gandhi, after the change of the government, Janata Party government came to power, she wanted to travel abroad. But the government of the day impounded her passport. She challenged it before the Supreme Court in a proceeding under Article 32. Article 32, you know, can move, it's itself a fundamental right, and it's a process through which the Supreme Court exercises the power of judicial review in addition to Article 136 or the High Courts under 226, 227. So Menaka Gandhi challenged it. that right to travel, which includes right to travel abroad, is a fundamental right. And you can't simply impound my passport without giving me a hearing. So this was a challenge. 7 judges of the Supreme Court overruled A.K. Gopal and then said that the procedure must not only be formal, it must be fair. It must conform to the requirements of fairness, non-arbitrariness, and by extension, compliant with the principles of natural justice. Thus, the American concept of due process, it is not formally included in our jurisprudence, but by way of this judgment and the subsequent elaboration of this judgment, this procedural due process clause has come to be firmly established into our constitutional jurisprudence. Now, why I refer to Maneka Gandhi? Because Maneka Gandhi can be said to be a watershed moment in the annals of Indian constitutional history. It has, following Maneka Gandhi, the expressions life, personal liberty, procedure established by law in Article 21 have been given a completely new orientation and expansive interpretation by the Supreme Court. Post Maneka Gandhi, the constitutional law has evolved in diverse ways. Broadly, I would just wind up now. Broadly, we can say one is the public interest litigation, PIL jurisprudence, whereby the concept of locus has been relaxed. Second is the human rights jurisprudence, comprising rights of prisoners within jails, convicts, accused under trial prisoners, right to fair trial, right to speedy trial, right to free legal aid. Then, of course, following this, we have this Vishaka guidelines, which says that sexual harassment of women at workplace amounts to violation of human rights. We have the manual scavenging cases, which were abolished by the Supreme Court. Then the 2015 NAGPUR judgment, whereby people belonging to the third gender have been declared as the third sex, constitutionally recognized as the third sex, and entitled to all the benefits which the Constitution provides each one of us. So this judgment, we have moved on from the binary of male, female into a third gender, male, female and the third gender. That this again, in Navtesh Singh's case, Section 377 IPC was struck down. That is not applicable to consenting adults. And in that, it is very important to note, the Supreme Court says that we go by our constitutional morality. We do not go by the public morality. And by extension, the Supreme Court as an institution is contra-majoritarian. It is not, it's distinction. There is a distinction between contra-majoritarian and anti-majoritarian. It's not anti-majoritarian, it's contra-majoritarian. We don't go by what the majority says to be right or wrong. We go by what the Constitution and the law says to be just and correct. We are not into the binary of is right, is wrong. No. For example, in a case of matrimonial dispute, the two persons may be perfectly good persons, yet because of incompatibility, they can't stay together. But that doesn't make one of them bad, the other good. It's just like that. We go by the law, not by what is good or what is bad. So, custodial violence is another thing which has been outlawed in D.K. Basu. Then, of course, state of Maharashtra in that PUCL case, encounter killings. All this happened completely negated by the Supreme Court. Finally, in that case of K.S. Puttaswamy, 9-judge bench declared that right to privacy is a fundamental right and which is traceable to Article 21. Now, Puttaswamy is 2017. We are just 8 years into it. According to me, like Menka Gandhi, Puttaswamy has got tremendous potential to unleash the constitutional law in diverse ways, to develop the constitutional law in diverse ways. And we are seeing it now, one case after the other. So, then again, connected with this is the environmental jurisprudence, which is again connected with PIL. MC Mehta and all those PILs you will find. The Supreme Court in Union Carbide developed the doctrine of absolute liability. Polluter pays principle, precautionary principle, which have together comprise what we call sustainable development, which is one of the constitutional goals of our republic. Electoral reforms. Supreme Court has said many things, including the striking down of the electoral bond, the infamous electoral bonds recently, and also about the appointment of election commissioner. Of course, this is a very live issue. The government has brought in an act which is subject matter of challenge. I will not say anything because it is within the Supreme Court will decide which way to go. So therefore, friends, this is where we stand today. As students of law, we are all students of law. I am a student of law, you are all students of law. We need to, I said today, we need to stop hero worshipping and critically look at ourselves and the judgments of the Supreme Court. Just a couple of months back, Kailash Satyarthi, that famous child rights activist, Nobel laureate, he came to my house in Delhi. He said, Judge, I am organizing a roundtable conference in Delhi about compassion in judiciary. So, it's a very good idea, and I want that you should come. So, I went there. So, it was attended by 10 sitting Supreme Court judges, including Justice Gawai, Justice Vikram Nath, 10 of us were there, and 5 retired judges of the Supreme Court, Indira Banerjee, Hima Kohli, Madan Lokur, Korean Joseph, Sikri. So, in that conference, I said, it's time we stop patting ourselves on the back. No doubt, Supreme Court has developed the law of this country. But we also need to look within, whether we have fallen short somewhere or we were required to do something more. I will not say, because that was a closed door meeting, what I said I will not say. Until and unless we look within, until and unless there is criticism, critical appraisal of what we do, there can't be any course correction. No institution is perfect. No human being is perfect. I have always said, there is no perfection in life. There is no perfection in law. A perfect judge is yet to be born. A perfect judgment is yet to be delivered. Just look at Keshwananda Bharati, it's the India's greatest case. It's all high on content, complete ambiguity insofar as lack of clarity insofar as the conclusion is concerned. So therefore, we need to look within and make periodical assessment. Supreme Court is supreme, not because it is supreme, but because it is the final court of the country. Many judges in the Supreme Court have said before, and I have no hesitation in saying so, that had there been a court of appeal above the Supreme Court, of the Supreme Court would have been set aside. So it is final only because it is the last court. So as students of law, I humbly request all of you to have an open mind. Don't accept anything at face value. Look at it critically. Analyze the judgments of the Supreme Court, whether it is in conformity with the text and spirit of the Constitution. In the process, you will enrich yourself. In the process, you will enrich the thought process of the new generation. Friends, I will not take much time. It's almost an hour now. Our Constitution has stood the test of time. We are all proud of our Constitution, but still it is a work in progress. We need to be jealously protective about our Constitution. before I conclude, I would like to remind myself and the audience as to what Dr. Rajendra Prasad had said during the concluding session of the Constituent Assembly. As the President of the Constituent Assembly, Dr. Rajendra Prasad had observed, it's so prophetic, and I quote, "We have prepared a democratic constitution, but the successful working of democratic institutions requires in those who have to work them willingness to respect the viewpoints of others, capacity for compromise and accommodation." These are the words of Dr. Rajendra Prasad. It's so relevant today. I congratulate Dr. Babasaheb Ambedkar College of Law, Nagpur, on completion of 100 years of its glorious existence. I am sure in the coming years and decades, this college will produce many more eminent lawyers, judges, academicians, and jurists who will contribute to the development of law in the country. To my young student friends, I urge upon you to leverage the resources, knowledge, and guidance available to you in this college and strive for excellence. I am sure you will be successful in whatever avocation you choose in life. Some of you, we don't know what the life has in store for us. Some of you may become powerful judges like Justice Sambre of the Bombay High Court. I would love to see some of you becoming Chief Justice of Guwahati High Court, my parent High Court, or Chief Justice of Telangana High Court, of which I was the Chief Justice. Certainly. So, work hard. The life, every day is a learning experience, and I'm sure with the foundation that you have got in this college, you can certainly look for a very, very bright future. I thank the principal, Dr. Ravi Shankar Moore, for inviting me to this great institution and giving me an opportunity to share some of my views with all of you today. Thank you very much, and God bless.
We are grateful to you, Your Lordship, for giving us this invaluable opportunity to be your ardent listener as you share with us your keen insights on Constitution and equality, of which lighter forms the root and former the stem of the flourishing tree we all call democracy. Thank you, Your Lordship.
As we near the end of today's event, I request Mrinmay Kukre Madam to kindly deliver the formal vote of thanks.
Respected Chief Guest, Guest Speaker, Honorable Justice UJJAL BHUYAN, Judge, Supreme Court of India. Honorable Justice Nitin Sambre, Senior Administrative Judge, Bombay High Court, Bench at Nagpur. Honorable Vice Chancellor of Rashtrasanta Tukaroji Maharaj Nagpur University, Dr. Prashant Bokare Sir. Respected Principal of our own college and Head of the entire BACL family, Dr. Ravi Shankar Moore Sir. Dr. Pravina Khudravadi Madam, Dr. Adhara Deshpande Madam, Justice Rohi, Justice Gilani, respected Samaji Bansod, teachers, and my dear students. A star-studded evening indeed. It is never easy to express gratitude. I would like to thank Justice UJJAL BHUYAN on behalf of our principal and the entire team of JUSTA CAUSA for so graciously accepting our invitation and sparing his valuable time and gracing this function. I would like to express gratitude to Honorable Justice Nitin Sambre Sir for being with us this evening. I wholeheartedly thank our own Vice Chancellor Sir, Dr. Prashant Bokare, for his love and support to the college. The program would never have materialized without the support of our principal, Dr. Ravi Shankar Moore Sir, Dr. Pravina Khudravadi Madam, Dr. Adhara Deshpande Madam, Advocate Sanjay Brahmi, Ms. Sakshi. Special thanks to Madam Supriya Ranade and Ms. Harshita Pandey. The zeal and enthusiasm can be seen blooming on the faces of the students' task force, sir. To mention a few, Tanay Virendra Dayal Ayush Anuj Yug Veda Rituja Shreyas Sejal. Pardon me if I might have missed some student. Thank you, dear students, for your timeless effort, zeal, and strength. I thank the entire elite teaching fraternity and the elite members of the Nagpur Bar Association for respecting our invitation. Lastly, I would like to again thank Principal Sir. Sir, with each Justa Causa, you take the college to newer heights of glory and stardom. Thank you.
Thank you, Mrunmayee ma'am. Let us all rise for the national anthem.
We once again express a gratitude to Honorable Lordship and dignitaries of the dead, luminaries and esteemed guests present in the audience, participants, students, and teachers. We thank you all. Thank you.
अनम्यूट ही करो
Semi-finalists of the trial advocacy round are requested to stay back.